So, hello again. I hope you enjoyed the lunch. And I will now talk about the design reform in the European Union. So, let's start why, when, what. These are the three questions that I will try to reply today in my presentation. So, the why, well, basically, as we all know, we are trying in different parts of the world, in different jurisdictions, to adapt to these new realities. In the case of the European Union, there was a consultation, there were some studies asking people and users of the design system, European design system, what they would need to be clarified, to be aligned maybe with trademark systems. And basically, as I said, already in my one of my previous presentations, but I think it was the first day. The design system has not been changed since the very beginning when we started registering designs. So it was already for more than 20 years that there were no change, and we know that the world evolves. So the European Union, the European Commission wanted to improve accessibility, efficiency, and affordability of the system, modernize it, and clarify the definitions, which we've seen already this morning with Christina and in my previous presentation. Also, align with trademarks and also simplify the fees regime because it was a little bit in designs. There were several fees. It was a little bit complicated sometimes. And finally, as we all know, there is this issue of spare parts. So this was also clarified in the regulation. So here quickly the phases of the regulation. So it's been published in October last year. The first phase entered into force 1st May this year. So we are currently in this first phase. And the second phase, we provide even more clarifications, more guidance to the users. It will be in July next year. And as I was saying, right now we are like in a transitional period. So we accept videos, but we still extract from them the 7 views, static views. As of 2026, this will change. We will get, because we have different regimes. So we have amending regulation now, but normally in the European Union, we have like additional regulations. So next year, we will also have the so-called implementing and delegated regulations, which will shed even more light, more details of this basic regulation. And also in our case, if there are some technical things which the regulations don't cover, but they gave mandates to our executive director to decide. So there are some works going on right now on thinking about these technical things, and there will be decisions of our executive director. And then this is for the European Union as a whole, so for our office. But as you know, the European Union is a community of 27 member states, and there is also a directive which they will have to transpose into the law. So they have even more time until 2027, and hopefully it will be harmonized uh, among the countries, and the countries together with our office will also have a harmonized regime. Okay, so the changes Christina already mentioned. So the basic change is the terminology. So we no longer talk about community registered design or registered community design as we are in the European Union. It's the European Union design. The office in the previous regulation, as I was saying in the first day, what's the office? You also work in an office. So now the regulation clearly states the European Union Intellectual Property Office. So here are these structural changes which I mentioned. This is not so relevant. The content is more relevant. So let's go further. Okay, so I think this is the core really of the changes of the regulation. So now let's go quickly one by one. because we saw it already in the previous regulation. So the design definition, we repeat it constantly, has been broadened to include animation, transition and movement in reply to these changes of the designs of the reality, the metaverse and the virtual worlds. Then the product definition has been also tailored to allow non-physical design protection. And even though I said in my previous presentation, we were already allowing designs like this one is registered for some time already, but now the regulation provides examples to the applicants so that they can understand what is object of protection. So the graphical user interfaces, items intended to form an interior or exterior like this one, sets of articles, etc., etc. So this brings clarity to the applicants. And also, like we've seen in this example of the light which enters into a room, this is like a kind of elevator. So also the object of protection is defined by the features of appearance which show visibly, which are shown visibly in the registration. So uh, even though this has been also already registered, now there is a legal clarification of this, so it's easier for the applicants now to understand object of protection. Then, concerning some other changes, where there are some changes related to the ownership, so I will not go into details of all of them, but here you have a list of the basic changes concerning the ownership. But what I think it's an interesting feature of the new reform is that also there is now the possibility, because then the designers would be seated before, but now it's already in the regulation, and there is also a possibility of change of name. And also another quite relevant change is that this design symbol. We know there is the C for the copyright, the M or R for trademark, and also now the regulation foresees the D in circle as the registered design. So this is again to help the owners, the applicants, that they can show that actually their creation is somewhere registered. It's a creation which has been recognized by certain entities. So this is also a kind of promotion, but also stating ownership of the design. Then also the exclusive rights of the owners were somehow expanded in some cases, but on the other side, there were some limitations included. So concerning the expansion, now as of the reform, now with this reform, the owner can stop counterfeited products from being transited through the European Union territory or being placed in another custom situation. This is very relevant for the enforcement of the rights, and also 3D printing. So again, the reform um, is is a little bit trying to be aligned with these new realities when we know that more and more things are copied or produced via 3D printing. We had actually yesterday with Linda very interesting exchange of views. So if you're interested how it is in Indonesia, you can ask her. It was really, we were talking about the 3D designs and the quality, the materials used, and so on. But in any case, in our jurisdiction, the owner can go against the act of printing when someone is trying to abuse, to copy their creation. And so these are the rights, but there are also some limitations which also in the era of that we have always the discussions my copyright, my design, what can be used, what can't be used in the presentations. For example, there is a big discussion what all these chats like ChatGPT, if they can use different materials, different creations or not. There are some voices who are against that. There are some creators going against open sources and so on. So it's a big discussion. In our case, with designs, there is a limitation of the right of the exclusive right of the owners when there is a referential use. So imagine that now I'm using, for example, examples in my presentation for spreading information on designs, or maybe a teacher in a school, he uses some designs um, to illustrate examples to teach someone. So this is the referential use. So it's a kind of limitation of the rights of the owners. But we will have to wait for next year to see how this is further developed. And also, we were talking before about public policy and morality, but here we are talking about the acts carried out for the purpose of comment, critique, or parody. So in this case, the right of the owner is also a little bit limited. So there were some cases, but basically related to trademarks, where some uh, trademarks were used in pieces of art for the purpose a little bit to indicating well, there were luxury brands, and there was a little bit making reference to social inequalities and so on. So this is a little bit that there was a court judgment about this case. So this is a little bit, in this case, related to the designs, the possibility for others to use the design to comment, critique, or make a parody. Also, the referential use is also when someone wants to compare different creations, different designs, not only for the educational purposes, but also for comparison. And also there is a change because we have we have European Union, and then there is a European Economic Area, which is a little bit bigger. There are some other countries in the European continent who are within this group. So there is a little bit a change in concept for rights. Okay, then spare parts, as I was saying, quite a relevant part. There was a transitional repair clause, and now with this regulation, with the change of regulation, it's been converted into a permanent provision. So the repair clause makes design rights unenforceable when the design of a component part of a complex product is used for the purpose of the repair of this complex product to restore the original appearance. This is very relevant. For example, I have a car, I had an accident in Europe, and I need to change the bumper. So this spare parts clause would apply to this to that problem, let's say that I had. Um, so it's to restore always the original appearance of the product which got broken or happened something, no? So also the manufacturers and sellers will have to the following obligations, which you see there, to duly inform consumers about the commercial origin and the identity of the manufacturer, and to ensure that these parts are used to repair the broken product, let's say. So there will have to be a clear indication of the trademark, at least on the packaging of that product. This is this, we call it the spared part provision, like it's called the must match parts, no? So it's related to the must match parts. It's not something different from what my car had. The bumper must match what I had before and the car as a whole. So as this was not aligned among different member states of the European Union, the different states have 8 years to align this, but it's already a very big step. I would say it's the second biggest change in the design law in the European Union. So then we have some changes. Well, the first one is just not so relevant, but it's that as of now, all the designs will have to be filed directly with the UIPO. Before we have the opportunity that the applicants could file in their national office of one of the member states of the European Union. Now they have to file directly with the UIPO. And also, the big change is that now the payment of the application fee becomes a filing date requirement. So, what does it mean? We have its alignment with trademarks. We call it, like we have the kind of slogan, no pay, no play. So, if they do not pay, we do not check, we do not examine the design. And well, the application fees must be paid within 1 month of filing, but also obviously the applicants have the possibility to pay straight, like that's one of the requirements of the fast track, for example. Um, and well, we have also an update, specimens. I don't know if you get any specimens in your offices. We don't get them anymore already for many, many years. So this was just eliminated. Now we get everything basically online. Now that I was talking about this change, so the unity of class requirement abolished, which is a very good news for the applicants, especially for let's say the small companies. Now, if they have they apply maybe for a car, they don't have to worry that car seats are in different Locarno class. This is not anymore an impediment. But on the other side that I was saying, now they can file up to 50 designs in one application. And also we changed slightly fees. I will show you the change later. And then the deferment of publication. There was a question before from the gentleman about the deferment. This is also a little bit changed with this legal reform. So the and also the fees are here a little bit updated, because before we had like two fees. It was the application fee and publication fee. Now the publication fee does not exist anymore. They were unified, but it's still 350 euros for the first design, for one design. And there were some changes in the fees for the deferment, but this deferment fee still exists. And the big change is that the holder can no longer prevent publication by not paying for the design. They must explicitly now surrender the design that they do not want to be published. This is also a change. Here are some changes also about the renewals. Renewal fee. Basically, what we've seen is that renewal becomes a little bit more expensive with this new regulation, but it's also a little bit too, it's my personal opinion, but I think it's a little bit to regulate the market, because why keep renewing designs which are maybe not they don't need to have been protected anymore. So that's why this renewal fee is a little bit higher now, and they are increasing progressively. So with each new renewal, it's more and more expensive. Yes, I think this is the most relevant thing. Yes, a little bit the dates change, but I don't think it's so relevant. I have some examples, but it's not so important. Then concerning the register, there is removal of some data. So from the register, because we don't think that so much data of the applicants is really necessary to be disclosed in the registers. So we're just removing some of them. And also Office database will no longer display the address, the nationality of the parties. And what's something new, and I think it's very positive, is that the inspection of files will be now only available online, but free of charge. And then concerning the invalidity, so the article has been modified to clarify the extent of 12-month grace periods, which apply when the previously disclosed design is either identical or it does produce a different overall impression from the EU design. But then the invalidity applicant will have to demonstrate legitimate interest. And well, these are some additional changes, but as said, I don't think that this is so relevant for you. I just wanted to list the most relevant changes. Just you can have a look on this, and then when we distribute the presentation, you can further check it. And if you have any questions, just send them to us, and we will try to reply. So the fees, this is another big change. Maybe it's not so crucial as the two others that I mentioned, but they are quite relevant also. So as I was saying already, there is the unification of registration and publication fee in one. Then the fees have been reduced, changed a little bit because we had like three brackets. So there was the application, the fee for the first design. Then from the second to the 10th, there was some other amount of money needed. And then as of the 11th design, it was a different amount. But now only there is a difference between the first design and then the rest. The renewal fees are higher, and there is a reduction of appeal and declaration of invalidity fee. There is also elimination of some fees. It's what I was telling you. There is, for example, the publication fee. It's no more is unified with application fee. And here you have the list of fees which have been eliminated. And here a small comparison. I hope you can see it. If not, then in the distributed presentation. But basically here you see the registration publication fee. Now it's only the application fee. And this multiple application, you can see maybe here that before it was from 2nd to 10th, it was 115 euros. And from the 11th onwards, it was 50 euros. And now it's 125 euros for from the 2nd to the 50th design. Also here you see this publication fee for multiple designs has been deleted, and additional fee for deferment. It's now always 20 euros. Here the renewals, you see the change. So the first renewal was 90 euros per design. It becomes now 150. So it's quite substantive change. Then second renewal from 120 to 250. Third from 150 to 400 already. And the last renewal is becoming more and more expensive from 180 per design to 700 euros per design. And yeah, the appeal fee, which I was mentioning, it's now aligned with trademarks, so it becomes from 800 euros it's reduced to 720 here. The rest of the fees are the same, like for license, right in RAM, levy of execution. These are uh, these are the same. And also here, some things which were not uh, payable before, there is a new fee for the alteration of a registered design. It's 200 euros. So here I just leave you also the link to a hub which we have on our website. So everything what's new about the regulation we posted here on our website. So the presentation has a link. I invite you also to read. You have the legal texts here and everything what is relevant about the reform. And also we have webinars in our learning portal. So if someone was super interested in the details of the regulation, then please check our learning portal. It's available for everyone on our website.